an injunction is an incredibly powerful bit of your data breach toolkit. When we say injunction, I think it's important to remember that that is shorthand for just an urgent court order of some sort. And that sort of is part of why it's so powerful, because it can be a very, very flexible tool and one that you can deploy very, very quickly. So certainly in the UK, you can get one in a matter of hours, any day or night around the year. What can you get? Well, you can get an order pretty much as at the court's discretion, but pretty much to do whatever you want. So that can be to stop people using your data. So if someone's taken your data, you can get an order to say, stop distributing it, stop doing anything with it. If you think someone is going to be receiving your data, so a newspaper or a competitor, you can certainly get an order requiring them not to use it or exploit it. But it works the other way as well, in the sense that you can require people positively to do things. So, for example, you can require an ISP to shut down particular data sources, or you can require third parties to hand over details of bank accounts or cryptocurrency accounts. Those are sort of attractive features and benefits of getting one. I mean, two other things worth picking up. First is, you don't actually have to know who you're getting it against. You can get an injunction against persons unknown. One of the more celebrated examples of this came when people were hawking around Harry Potter and the Order of the Phoenix, which again dates some of us, to sell that to various newspapers. And they didn't know who was selling it, but they got an injunction preventing anyone buying it, which was therefore pretty useful. But in a data breach scenario, you may get one where you think there's a rogue employee, but they're working with someone, you don't know who, so you get an injunction against them all. One other practical advantage is you can often do this on a totally confidential basis. So you can go to court, you can have your hearing in private if you need a hearing, and you can also have all the parties anonymised. So you get some recent examples where it's sort of ABC Limited or XYZ PLC against some other unnamed individuals. There are some challenges, obviously. It is a very powerful set of orders that you can get. So you do have to have a cause of action. Again, not necessarily that challenging. There'll be breach of confidence. There'll be sort of theft of data. There'll be things to get the action off the ground. And you'll need evidence. And we'll just come on in a moment talk to Ioan about how some of that might be gathered. You also have to think it through. Where are you going to be going next with it? It's all very well going off and having a nice, friendly High Court judge give you an order, but how are you going to serve it? We have, and you can get orders so you can serve it through darkroom chat forums or to the hacker's email address that they've given you to negotiate with. And who else might you want to give it to serve notice on? So is it just the sort of immediate recipient, or is it going to be, as I say, third parties like banks, or is it going to be against the sort of the service providers? Packaging all of that up, though, you are starting legal proceedings, so you have to think about, before you kick off and go and get an injunction, what am I going to do with these proceedings? In many circumstances, you can stay them while your investigation goes on, but ultimately you are going to have to deal with this as a parallel work stream. So, as Rebecca says, this is it's a very powerful tool, but one you need to build into the sort of the full sort of project management piece of dealing with a data breach. To get one, though, you're clearly going to need some evidence, both to get the injunction, but also to know what you want the court to order. And sort of there, as ever with the data breach, that's where the IT and the technical evidence really comes in. So, from your experience, what would you be classically called upon to produce and think about?
It depends, but it goes.
I'm the lawyer.
It goes without saying that technical evidence is really, really helpful in substantiating the story to a court, so that they know that it's based on fact, as far as is available anyway in the context of an early investigation. It really needs to be gathered carefully by ideally a third party, so that there isn't a perception of a conflict of interest, and we'll come back to that shortly. We need to maintain a chain of evidence, a continuity, so we can justify the integrity of the evidence in court. And from my perspective, we always gather it in the context that we will be expected to justify ourselves, that our actions are reasonable, proportionate, we've acted with integrity, good intent, and are prepared to swear to that in court effectively. So from the perspective of the type of evidence gathered, that's why I said it depends. So from the perspective of somebody inside an organization committing some kind of problem, then I would suggest you think out of the box and collect as much evidence as you possibly can. And think of every piece of technology that user's interaction with the environment touches, from the very edge of the network or even outside the network, thinking about cloud services all the way in. And I would seek or encourage you to seek expert advice, because people like my team are used to gathering that kind of evidence efficiently and at pace. Building on Richard's point about a person's unknown injunction, we use them almost routinely. They're really, really useful. First of all, in arranging takedown notices, so say that somebody's publishing something that you don't want to be in the public domain, it's confidential contractual information, for example. It's taken very seriously by the various service providers on the public platforms across the world. If you can demonstrate that you have the court's backing to say that this is effectively an act of crime, for them to then take your takedown notice really seriously. We also use it in a very iterative way as well. So it can help us compel people to assist with an investigation. So in one case where an organization's information was actually being ransomed and it was being hosted on a third-party platform, we used the threat of litigation based on the back of the person's unknown injunction to compel the ISP to be more cooperative than they would have otherwise. Partly because the attacker hadn't actually paid for the hosting, so hadn't paid their bill, which is quite nice.
Yeah, so clearly you've heard from us. I mean, Carl, from the organisation's perspective, was this obvious? What made you think about it when you were looking at this?
No, it's a good question. It certainly wasn't obvious. I think our situation, our data incident was a kind of rogue employee sort of situation, and in terms of the drivers for us, it was very much a number of the reasons you've kind of already given. It was a chance to protect the data so far as we could in the circumstances of what had already happened. We thought it was right in our customers' interests to frankly take as many steps as we could do to protect that data. We really did see there was a chance in our particular circumstances that we might be able to recover it or at least stop it getting any further, and that weighed heavily on our minds. It was always the obligation, as we saw it, to try and do that. It was also clearly a way of putting pressure on people we thought may have been involved in the matter, whether we knew who they were or we didn't, as you kind of said earlier. And I think it was particularly critical for us that it was a really early stage when we were looking to do this, when you didn't have all the evidence, didn't have all the information, didn't have all the facts. We didn't quite know what we were dealing with in its totality. And just simple things like getting access to the evidence. I mean, we could access our servers, our own work devices to the extent we have them, but the relevant individual, we didn't know what other devices he or she may have had, where they may have stored them, other communication methods. Could we have found out more things if we could get hold of devices and information? So we thought that the injunction could have been a very powerful tool for sort of doing that. But it wasn't a slam dunk for us, if I'm honest. Just sort of thinking about the nature of our organisation. It's almost a question about morality in some ways, put it bluntly, suing your own employees, particularly at a stage when you don't necessarily have the perfect information you want to have. It's a pretty bold step, and secrecy, etc., involved in that. You've got to be, you've got to have some. Your organisation needs to have some guts to want to do it, and we did get there in the end, but it wasn't plain sailing, and there was certainly a piece of work that we had to go through internally, not only the usual governance aspects of approving things, but just getting people to agree that it was the right thing to do. And it wasn't, and doing that in a very, very quick time frame. The window of opportunity was kind of was closing as we felt at the time.
Yeah, and that sort of tight time frame and the lack of information is a key theme that obviously runs through many data breaches. I mean, classically you get phoned up on a Friday night and you're in court over the weekend to get one of these, and before everything then happens and people are back to work and it's all public again on Monday morning. But I think picking up on that sort of the challenges around information, and moving on really to the sort of the second core thing to talk about is actually the IT investigation and the report and some of the practical sides of that, because for all of us I think we'd see this as both an internal and an external piece, and there are challenges with both to make sure that the organisation that is affected by a data incident of some sort gets the best out of its own internal teams who know and work and are committed, you hope, and any third-party expertise. And because I want to have a go with the fans, we're going to ask another question. So the question: how many yes or no? So green for yes and red for no have got third-party IT forensic expertise appointed already under general terms, ready to go? Okay, so quite a lot of green. Some red. I think the question stands for both, though, whether you've got them appointed or not got appointed, and picking up the timing pressures we've just talked about. How many of you are confident that if you had a data incident and you needed third-party IT forensic support, you could have them in the building in, let's say, 12 hours? Oh, pretty good. How about 6? Less good. So I think, bearing in mind some of that time pressure and stress that comes with it, I think, moving on to your sort of, what should clients be doing to get the best out of their internal and their external sort of IT teams?
Sure. So hopefully you've never experienced it. It is a pretty horrible place to be, where the bottom falls out of basically the internal team's world in a few minutes' time. Something awful has happened. It's going to have a detrimental impact on the company, its reputation, its employees' family, potentially. And if it isn't handled correctly, then damage is going to be done. So it's down to you guys, the people in this room, as well as the board and the various advisors, to contain that and mitigate that kind of impact. This is really tough. A first observation for me, being on the outside and seeing this quite a lot, is that internal teams can be emotionally involved and also a bit conflicted. Imagine if you've built this fantastic enterprise and somebody's found a flaw, they've used that flaw, and now they're using that to cause harm. It's very visible inside a company, and generally people feel absolutely awful. Also, internal teams are really focused on delivering business as usual. So they're about moving the enterprise forward and doing good, not limiting harm generally. So I would encourage you to, as many of you already have, retain the services of an external team. Generally speaking, it's some kind of insurance, incident response, external counsel, even PR agencies, and know how to call on them. The skills of an incident responder is really, really broad. It's not just technical, although a really deep technical background in the cyber world is essential. It's also being able to think from the perspective of the adversary and to try and plot through the circumstances to know what kind of information to gather first, how to process that efficiently, and arrive at the facts of the matter and to find out what's happened. And that comes with a huge amount of experience and enables then the investigation internally to focus on the next best actions to try and limit the damage, to inform stakeholders, inform regulators, and so on and so on and so on. So from the perspective of the report in particular, it's always quite tricky to write because the issue of privilege and future legal action, future regulatory action and so on needs to be taken into account. But it needs to present facts through the means of telling a story. A legal team doesn't really want to learn the kind of technical knowledge that I and my team has. Neither does the court, quite frankly. So if it can't be easily understood and interpreted, then it's really difficult for anyone to see value in its use. Goes without saying that has to be purely based on fact, no conjecture. And it has to do that translation in an efficient way so that if somebody appoints an expert to try and contest an opinion, then that expert, given the same evidence, should arrive at the same conclusions. It also has to be structured in such a way that it answers the questions of various stakeholders, including regulators, so credit card payment schemes, privacy regulators, and so on. And from my perspective, it should also include helpful factual advice on recovery, how to prevent and fix some kind of systemic error that's caused that harm or led that harm to be caused in the first place.
Yeah, and I think to pick up a couple of those points from the lawyer's perspective, you're absolutely right. The privilege analysis is difficult, and the case law on that recently has been more challenging. I think the distinction is if you're in a litigation scenario and you're preparing your report for the purpose of that litigation, you might be privileged then. But if it's more advisory, much less likely to be so. So I think your points around having to be factual, be objective, not expressing unsubstantiated opinion are really critical. And that can be quite a tension when you're thinking about the internal and the external technical input here. And working hard with an organisation's internal team so that what you don't get is the sort of a tension that might then have to be disclosed or produced either to a regulator or if there is sort of follow-on litigation of the internal team saying one thing, the external team saying another thing. And at best you've got an impression of confusion and challenge in that scenario. And I think that sort of really is the nub of a lot of the IT technical challenge in terms of where's this going to go. And I think, as you mentioned, there's a sort of reporting and producing the information as you know it at that particular moment in time, but looking forward as well and thinking hard about whether you need to separate those two, because you don't necessarily want to be reaching conclusions on the recovery, the remediation type side of things before you've done more of the sort of what's actually happened, root cause type assessment.
Yeah. I'd also add that from my perspective, working efficiently with the internal team, it gives us every chance of succeeding. There's no one that knows the infrastructure better, the company better, the circumstances better. Yeah. So having that efficient relationship where the internal team is focused on giving access to information and guiding and helping is ideal.
Yeah.
Thank you.
Great. Yeah.
Carl, what about you? And what's been your experience in coordinating the efforts between the internal and the external side?
Yeah, a number of the points that the Richard and Ioan have sort of picked up on. I think it's key in those early days to be clear on what's internal IT doing, what's external IT doing. Is it a bit of a is external reviewing what internal have done? Is it giving a second opinion? Is it an expertise you don't have internally? Kind of what is it? What's the scope of that? Being clear. From the legal side, I think it's getting in that conversation early, depending on the nature of your breach. Your IT guys may be running already, they may be writing reports, they're issuing bits of paper left, right, and centre. The number of times I had to read documents with the threat actor in them just kind of blew my mind in those first sort of 48 hours. You want to get in that conversation quickly, and particularly, IT may not have engaged external IT already before you get engaged. So you saw earlier a number of organisations have already got them on standby. Be in that conversation, help to guide why we're bringing someone external in, at what point and why. And as an organisation with not having unlimited funds, cost is a point to talk about. And whether or not you think you should throw all money at the issue or not, it's certainly a really good litmus test for your boards as to how far they're prepared to go in dealing with this matter. You start to see the fees for some of these guys, then you're going to have a really good sort of test how pretty early on as to how seriously is your board taking the matter. And I think it's also good to keep that kind of scope under review. I mean, the shape, if you like, of your investigations might change over time. So you start off with a particular proposition, and then you sort of, new facts arise as they always do, particularly if you've got a period of time in which to investigate, and new things will change. So you keep looking at that scope. Is it appropriate? Do you need your internal and external teams to diverge or converge depending on how your investigation is is going. And I think it's really key to make sure your internal IT guys are adhering to many of the rules that sort of Richard and Ioan have already talked about. Don't let them speculate. You know, they're going to be really close to what's gone on. You know, they're really invested, like you are, like your board is, like your other execs. They're really invested in your organisation. And when you have something like what happened to us, you know, they want to come to conclusions. They want to be the one, you know, they want to be the hero to find the answer. You want them to be as factual as possible. It's all about the evidence gathering and what you can use later. And it's really hard not to be in the moment for those who you know, kind of seen it. And you want to bring a bit of that kind of cool objectivity, and you need your IT guys, internal and external, to do that.
Yeah, thanks. So we've sort of had a quick rattle through two topics, which are sort of the injunctions and the IT reports and the investigations. And just the other topic we wanted to look at was sort of around employment issues, not from the fact of being employment lawyers. I'm not an employment lawyer, and I'm guessing we probably don't have any employment lawyers in the room, or at least people who are solely focused on it, but really looking at how that work stream ties into the other work streams, because certainly when you look at the statistics, yes, everyone talks a lot about cyber breaches, but an awful lot of these are actually where there is some issue internally. It may not be a rogue employee, it could be accidental, but that is certainly, I think, where the majority of them are. Richard, maybe over to you. What are sort of some of the considerations from the sort of the other work streams perspective here?
Yeah, I think as you touched on, it's a really difficult balancing act because, you know, as Ioan says, the sort of bottom falls out of the IT guys' world. This looks and feels dreadful. There's enormous pressure within an organisation to do something and to react quickly. And inevitably there's often a degree of sort of casting around, well, someone's done something wrong here. There must be something or someone to blame. And balancing, you know, what you should keep in mind is a sort of, you know, fair and proper treatment of, you know, everyone involved versus the risks of not acting quickly enough, the potential harm to the organisation is really difficult, particularly in circumstances where you may not know up front, you know, is this a rogue employee, the sort of, you know, classic Morrison's example where they, you know, were a bit upset about their mailroom treatment and so off they went, or is it someone who has, you know, been struggling with the IT system and has forwarded some stuff to their personal email because it's a workaround because the IT system's a bit clunky. You know, both are data breaches and both are bad, but they're sort of clearly different levels of culpability. It is quite a challenge to get that right, and you know, from a technical legal perspective, you would want to get HR or you know, proper employment advice involved as soon as possible. I don't know, I think sort of, again, time for another fan question. So to take a scenario, and maybe, you know, you'll be coloured by your own experience of dealing with this, and I'll obviously set it up as a balanced question, but let's say you have caught an employee who is deliberately leaking sort of very sensitive data about colleagues to the general public. So, you know, it is people you work with, and their data has gone out the door. The individual in question has admitted to this whilst you've been interviewing them. There's then a debate between, you know, the workstream heads, so you've got legal, you've got an HR. Should the employee be dismissed? Green for yes, red for no. Oh, there's a lot.
I was going to say, there's an awful lot, I think, of, a bit more hesitant on that one.
Yeah.
I know, we
So
made it tricky.
should the employee be dismissed?
Should they be dismissed immediately after that confession?
Yes, so they've said, yes, I've taken the data and I've leaked it. Do you dismiss them straight away? Okay, so Carl.
So I think that demonstrates the challenge of the question. There's a lot of not sure's, I think, there, and of splashing of reds and greens. So not surprising. It's not straightforward.
It is not straightforward. I mean, Carl, from the organisation perspective, you touched on some of this already. What were the kind of practical experiences or concerns that you came across?
Sure. Yeah. I mean, the obvious one, you know, if HR are involved already, get them involved. You know, you'd be surprised by. Some of your organisation is very large, and if you've got your employees in Jordan but your HR is based in Australia, you know, when do they wake up and when do they get involved? So getting them involved straight away is obviously key. Similar with the IT guys, if your HR guys are the ones who discover it, make sure they know who to call, i.e. call you first and your risk team and your IT team, etc. So, you know, there's the usual stuff about having your crisis management framework up to date, your contact list, your BCM, all that kind of stuff ready to go. I mean, a lot of it clearly depends on what's your scenario. You know, what's your the individual you're looking at, what are they saying? Are they confessing? Are they denying? Are they hostile? Do you think you're going to need their help going forward? I mean, there's one thing coercing someone through injunction or otherwise. There's another thing getting cooperation from someone who may have seen the error of their ways potentially. So the scenario is going to depend a lot on kind of what's happening in practice. We're in a regulated industry, I think regulated other than the ICO, so there may well be other authorities such as the FCA in the UK or other regulators who may take a great interest in that individual, particularly if they are holding a regulated function, for example. So there may be other people who want to speak to them, and if you've just kind of fired them, then that's going to be 10 times more difficult. So there's kind of a practical piece there, thinking about what do your regulators expect. And then I think there's a lot of real practical stuff. So, if you've identified persons you want to talk to, where are they? Are they on holiday? Do they work in the building across the road? Do they work in Australia? Like, how do you actually get hold of these people? Where are their devices? If you've got really good lockdown password protection systems, how can you get access to systems and those kind of things? And I think a lot of the conversation we had internally was that real balance, a little bit we talked about earlier around wanting to take the right action to protect customers and protect the group, but not jumping to conclusions and meaning that we could be wrong, and the actions you take now will be judged, frankly, in the cold light of day in 6 months, a year, 3 years' time, and you've got to kind of have that mindset and balancing those risks at every step with imperfect information, with things moving at speed, and a lot of voices in the room shouting you, not only HR, you've got the board, you've got the risk and compliance, you've got different colleagues telling you different things. So trying to weigh all those up becomes practically difficult.
Yeah, and I think you're absolutely right. Your point around being clear around your documentation, your decision-making process, again, in an objective and neutral way as much as you can, because as we all know, you have to document what you do about a breach, but you'll have to have a clear record if there is going to be a set of employment proceedings later, which proceedings may, of course, be public. So you'll be rehearsing many of these unpleasant and difficult points in public, and you'll want to have your record, not the I didn't sleep for 48 hours and then I sort of had to have this rather difficult conversation and no, I didn't take a note of the meeting, is not going to be a great place for you to be sitting there as an organisation. So, but the information is critical. So I mean, sort of how can the sort of the IT forensics help in this sense, quickly to help solve this, should they stay or should they go type conundrum?
Yeah, I guess from my perspective, it's really a challenge for me to get ahead of the internal story sometimes and make sure that the evidence is preserved before somebody is fired or changes the information or deliberately tries to hide something, for example, if there really is cause for concern. So for us to get ahead of the story is really key. Also, as an organisation, it's useful to think about how are you going to get access to this data if you really need it. So, for example, if an employee is allowed to use their own device, do you have a right to access that? Can you access the encryption? Depending on the jurisdiction that you're in, some countries have extremely restrictive controls around access to personal information. I don't need to preach to the converted, obviously, but I've seen investigations that have been delayed by days and weeks while the legal team argue internally whether or not the investigation can access the employee's data to begin with, to find out if there is a just cause to be concerned. So sorting things like those out in advance is really useful, along with taking into account things like whistleblower status and how that would play out as well, for example. From my perspective, we can work with the investigating team to really test the story, test the employee's account, and help guide the team on the art of the possible. So what information sources are available to us? How can those be used to best tell the story? And what are the limits of that investigation? And of course, what are the costs involved? How can we be efficient in processing that amount of data to distill it down to what actually happened?